We're going to bring Faye Morrison up real quick, and then we'll get to Mike Noel next. Miss Noel, oh my God, long day. Sorry, I apologize, Miss Morrison, for that. Miss Morrison, can please identify yourself for the record?
Yes, sir. My name is Faye Morrison.
All right.
I'm an attorney for Department of Public Safety, Office of Legal Affairs.
Do you still work for state police?
Yes, sir.
Okay. Representative Jordan has a question for you.
Well, I don't know if it's afternoon, evening. I don't know what time it is at this point. First of all, how are you doing today?
Okay.
Good.
Thank you.
And I know when we had the use of force task force back last year, you testified before the committee that I was chairing at that time, right?
Yes, sir.
All right. I'm gonna come to that in a second, but I want to hit some of the things that they talked about today. What's your position right now?
I'm an attorney 3.
Attorney 3. What was your position back then?
I was the assistant secretary
Assistant Secretary.
for Office of Legal Affairs.
Would that be the same as General Counsel, or would that not be?
It's not the official title, but it was referred to as General Counsel.
Okay, no problem. And I guess you remember back then we were talking about at some point we were talking about the August McKay matter, and that was one of the issues that had come up at that time, right?
Sir.
All right, and you were involved in I guess you heard me talk to Doug Kane about this, but trying to redact his name and some things related around the McKay matter, correct?
Yes, sir.
All right. Let's talk about these phones being sanitized. We've had litigation holds within state government for some time. I mean, 20 years or so. Wouldn't you agree?
When we're put on notice of a litigation hold, state police did not have a litigation hold policy. When we were on notice from the Attorney General's office, who represents us in our tort cases, if they put us on notice of a litigation hold, we would perpetuate that.
But you didn't have a policy while you were Assistant Secretary / General Counsel.
No, sir.
All right. Why not?
It was not in the policy, and it was not called upon for us. And the department has a retention schedule, and that retention schedule covers the great majority of the documents that we maintain.
All right. So what was your role as General Counsel? Was it to advise and protect the department?
It was to run the legal affairs department and to provide advice as needed. Our role was not to oversee any part of public safety. We were called upon for legal services, and we provided those legal services as needed.
No, I understand that, but I know Colonel Edmondson spoke about it, Colonel Reed spoke about it, but wouldn't it be good policy, a good practice? What I talked about earlier with Lieutenant Colonel Kane, some of the best practices to have a retention policy in place, or some type of litigation hold policy in place. Wouldn't that have been good?
Well, we do have a retention schedule policy.
Right.
I mean, we do have a retention schedule. So most of our documents across state police are scheduled for 3 years. So generally speaking, that covers most notices of litigation. And so at the 1 year point or 18-month point, when the lawsuit comes in, then we are on notice from the Attorney General's office that there is a lawsuit and that they're collecting documents, and in certain circumstances they've provided us with litigation holds. Not in every case, to my knowledge.
I understand. So, and I'm gonna just for brevity of time. Were you involved in creating the policy that you have in place now?
To a very limited extent, yes, sir. I was asked to do that when I, back in August and September of 21. But I think prior to that, Ms. Gail Holland had recommended that the litigation hold be done, and she effectuated that during that time period.
You think it's a good policy?
Yes,
You think it's a necessary policy?
not in every case. And to the sense of police officers put their hands on people on a regular basis in a lawful way. But there's always a potential for, you could say, okay, I might get sued for that. So to put that on employees on every circumstance seems a little burdensome, but I think that's the policy.
I guess the question is, so you think it's okay for anybody that has potentially has public records on their phone to just go into an IT guy and say, just go ahead and wipe my phone, and there's no oversight, no accountability, no repercussions, none of that stuff, the way it was done prior to this policy being put in place?
No, sir, and I was not part of that. I did not have any participation. I was not put on notice. I was not advised that anyone was doing anything of that nature with the phones. I know that you reported that on one of the local news stations, that you understood that I was the one who gave the order. I had absolutely no knowledge of when Colonel Reeves turned in his phone, when Colonel Noel turned his phone, or when Major Kane turned in his phone.
So you're telling me you're responsible for some of the policies, or at least advising on policies to be put in place? Because this policy came out of the Legal Affairs Division, right? The one that's in place now.
Yes, sir.
Okay. So that would be part of your responsibility. It would have been part of your responsibility, right?
If asked to do so.
Okay. And so who would have asked you to do so?
Either Colonel Reeves or Colonel Davis or
Colonel Edmondson or whomever. So how long were you in that role?
I was in the role as assistant secretary from July of 2017 under Colonel Reeves.
Okay. So you're saying you only would have advised on that if somebody asked you about that?
Or if it became a problem or an issue, if we had an instance during that time period where someone had destroyed evidence, but we had not had an incident where someone had destroyed evidence. So it wasn't an issue that came up where we said, oh, you need this at this point.
Well,
Rep. Jordan, you're at 6 minutes if we can wrap it up.
That's fine. And look, here's what I'm going to say. I think Representative Villio talked about that we had this Vegas trip. You knew that was an issue. You know that was potentially something about somebody destroying evidence. So you didn't do anything about that. I'm going to switch gears just for 1 second, and I'm going to ask you this one question. And so I know you're doing things, you're saying only when you were asked. But it seems like the emails, at least one of the emails that you sent out regarding the Ronald Greene incident, seemed to participate in trying to cover up or shield these officers from liability. And I understand that you may not have wanted to see the video, but I'm assuming you were aware of some of the facts and circumstances surrounding his death, and to try to say that you were going to pass it off on it still being an accident seems problematic to me. Do you agree with that?
No, sir, I don't agree with that.
Okay.
So I'm glad that you asked. So there were two different emails that I think you're talking about. The first was not related to the Ronald Greene matter. The first was related to a case that came out of New Orleans that had been in litigation. We had outside counsel that had been assigned by the Attorney General's office. We were being defended by the Attorney General's office. And in that case, the issue of you couldn't have a criminal charge, a criminal conviction, and a civil claim controvert one another. So if there had already been a criminal conviction that the federal courts ruled that a civil claim of excessive force, where there was a guilty plea or a guilty conviction on resisting arrest, that the case would be dismissed.
But that's not fair. That's not actually accurate, though. That's not accurate, because somebody can still plead guilty and be charged with a crime, actually be guilty of a crime, and an officer still can exert excessive force on them. So just that in and of itself is wrong. I just want to be clear since you're saying that.
Correct, sir. You're absolutely correct. And that email was not about the Ronald Greene case.
I understand.
That email went to lawyers. It didn't go to troopers. It went to lawyers, so that lawyers were aware of that when people were trying to settle claims before the criminal case had gone to trial. And I specifically referred to, I said, I have one in Troop F that I've got my eye on. Well, that was not the Ronald Greene case, because the Ronald Greene case would not have had a criminal conviction for resisting arrest. So it would never have been applicable. There was another case that was ongoing in Troop F, and we provided that information to the reporter who had asked for the email that it had been leaked to him. And we advised him that that was not about the Ronald Greene case, but it was about a case that had occurred in Troop F, and it was a handcuff case, and the case had been ongoing for several years, and the criminal case kept on getting pushed off and continued. And in the meantime, they were trying to settle the case with us and trying to get us to pay on a case that was still under criminal. So that was the note on that.
That's fine. Look, here's my last question for you. When you came to our committee before, we talked about Giglio concerns, and you talked about you didn't have a no-call list and all these other things. And I went back and I looked at the video last week, and you said, look, if we ever have any of our officers have conduct that rises to that level of Giglio, they would probably be terminated. And that's what you told me. Now, you knew about the Ronald Greene matter at that time when you made that statement. So you're telling me that none of the conduct by these officers raised any type of Giglio concerns or any type of excessive force concerns to you, because we hadn't had any of them. Well, one was scheduled for termination, but some of these officers are still employed with the agency.
Yes, sir. And during that time period, the criminal investigation was pending. All of the testimony that I've heard between Colonel Reeves and Sergeant Paxton and Sergeant Brown, the investigation had been conducted. The investigation had been submitted to the district attorney's office, and further than that, I had been informed that the investigation had been referred to the feds. So it was not my choice whether to do an administrative investigation at that time or not, but the focus was on the criminal investigation to take precedence over the administrative investigation at that time. And so there had been no findings at that time. And had we received a Giglio request on any of those officers during that time period, we would have reported that they were under investigation. But I did not receive one during that time period on those officers.
Ms. Morrison, you testified about a retention schedule. We had requested a retention schedule and we did not receive any. Can you make that available to this committee?
Upon approval of my supervisor, yes, ma'am.
Sure. And real quickly, you're talking about a Heck versus Humphrey bar when you were talking about the email, the Heck versus Humphrey bar, where the criminal suspect who then becomes a plaintiff in a federal lawsuit, if they've been convicted or pled guilty to the underlying criminal action, then they're barred from bringing a federal lawsuit for civil rights violations. Is that what you were referring to?
Yes, ma'am.
And obviously that would not be the case in the Greene incident, because Mr. Greene was deceased and therefore not charged with any criminal violations in this matter, correct?
Yes, ma'am.
And just quickly, you referred to, believe the litigation hold or preservation hold. Please tell me that you did not wait for the Attorney General to tell you you received a lawsuit in order to ask for preservation of evidence in all cases.
We did not, ma'am, but our retention schedule covered those things. Nothing during the first year, nothing during the first 3 years is going to be.
Should have been destroyed.
Should have been destroyed.
I just wanted to make sure, because obviously there are other incidents, and we know that plaintiffs sometimes don't sue for a year.
Correct.
And the whole purpose of a preservation memo is in anticipation of litigation, that the Attorney General wouldn't necessarily know of the incident until a lawsuit is filed. And I just wanted to make sure, as legal affairs, that that's not the policy of the state police, to wait until a lawsuit is filed to issue a preservation memo in every case.
And again, we were not issuing them in every case. We did have instances where when we thought litigation was likely,
Sure.
that we would advise the Attorney General's office of that, and then they would take action or ask whatever we needed. With regard to some of the earlier questioning, they were talking about the 2016 litigation hold, and I didn't participate in that, but at that time there was in fact a lawsuit filed, and we were on notice, and there were particular parameters of what things people needed to save and who needed to save those things.
All right. Thank you. Representative Hughes.
Thank you. Thank you, Madam Acting Chair. I'll be really quick. Attorney Morrison, what's your current title?
I'm an attorney 3.
Okay. And prior thereto, what was your role?
I was the Assistant Secretary for Department of Public Safety, Office of Legal Affairs.
From what years to?
July of 2017 until June of 2021.
Okay. So you were reassigned by Colonel Davis?
Yes, sir.
Okay. I apologize if I missed this or if this was already asked, but is there any policy in your agency around emails? How long do you guys preserve emails, or do you preserve emails at all?
The emails are housed at the Office of Technology Services, and they go back very far.
Okay. And how long has that been the policy?
Again, we don't maintain them. Office of Technology Services maintains them. Even the deleted emails, they're all there.
Okay. What about financial records? Do you guys have a policy that you retain financial records for a certain period of time within your agency?
I would expect that our retention schedule for the Office of Management and Finance, that would cover that. I don't have a specific recollection of it, but I would expect that they have retention schedules on that.
I'll yield after this, but you made a comment a little while ago when you said you guys never had a situation where evidence was destroyed that prompted you to have to implement this policy around cell phones. I would have to conjecture that that's not true. I think it was entrenched in the culture, and that's why some higher ups and others just felt so comfortable doing it, because it was done on a regular basis.
Well, we always advised against that. We've had, we advise troopers and all people, if you're at the accident scene and you take a picture on your phone, that's evidence.
I think, but for this high profile incident, you guys still wouldn't have this policy in place. And we still have cell phones being wiped fairly easily. And I think it's reprehensible that it took you all this long. And so many of you, current and former members of the top brass, have blood on your hands. And that's just the facts. Thank you, Mr. Chairman.
Thank you, Representative Hughes. One quick question. I stepped out for a little bit. You recall so may have been asked, you recall the meeting with Trooper Davis?
Yes.
Was he limited in his viewing based off of anything that happened in your meeting with him?
No, sir.
Okay. I should be very clear on that point. I want to give you the opportunity to clear that up. That's it.
Can I speak to that a little bit further?
Oh, sure. Absolutely.
Yes, sir. And I know y'all know that I'm an attorney, and the information that I have is client information. It's not information that I'm supposed to divulge just to
And I don't want
anyone
you to. I want to be very
under
clear.
any circumstance. But there's been a couple of things that have come up today that I feel compelled to address because of the way that it was presented. First of all, with regard to the meeting with Mr. Belton, I was asked, Colonel Davis asked me to attend that meeting with them. I was informed by Colonel Davis that as he testified, Mr. Belton had asked us to go and visit with him and discuss the discovery of the Clary video. And we did so. And that was a healthy legal discussion among law enforcement professionals. But in no way, shape, or form did Colonel Davis or Colonel Kane or Colonel Kamen or myself try to impose a specific narrative on whether or not to charge any of the troopers, including Trooper Clary. As Colonel Davis discussed, he viewed the video differently than from what Scott Davis discussed. And that was the crux of that meeting. There was no influence placed on whether or not to charge anyone, but there was a discussion at Mr. Belton's request. So to say we went up there with the goal of changing their minds or with the goal of influencing them not to charge someone, that simply didn't happen.
Okay, I accept your testimony. I don't have any reason to believe that that's not accurate. I just want to give you the opportunity to clarify the record.
And with regard to Scott Davis's testimony, he never, in the meeting that I had with him that he discussed at the end of June in 2020, he never said or characterized the Ronald Greene video as he characterized it today. He did not say those words in any way, shape, or form to me. The purpose of that meeting, from my recollection and my understanding, was exactly what he said later on. He didn't want to be viewing the videos anymore because he didn't see the point.
I really don't think you should be discussing what he told you, though. I mean, I think that's probably inappropriate. But
well, he's accusing me.
He's not. I don't think he made any accusation of you, and you still have a duty to uphold your clients regardless of what he accuses you of. And that's the sad, unfortunate reality of being a lawyer. Something I understand. So I'm gonna ask you not to tell you what he told you, but I would like to say is, did he request the meeting with you, or did he request with somebody else, and then you contacted him? I would like that part clarified.
From my recollection, they requested the meeting with me. I wasn't sent. Captain Slayton, and I think Captain Slayton asked me on behalf of Scott.
To meet with Scott.
Yes, sir.
Okay, thank you.
I was not directed to go there by Colonel Reeves or by anyone else in the senior
Scott
staff.
didn't contact you. I hate to say it that way. Trooper Davis did not contact you. You were contacted by one of his superiors because he was looking with somebody to meet with, is how I understand it. That's accurate?
I can't swear to it, but I believe I was asked to go by Captain Slayton, but it was at Sergeant Davis's request.
Gotcha. Thank you. There are no other questions for you, Ms. Morrison. I appreciate you coming today. Oh, you want one more?
Oh, I did.
Yes, we do. Do you have anything else you want to add?
Yes, sir. Could I speak to the force report that was sent to me again by Captain Peters? It's been alleged that I attempted to do something with that force report that was discussed earlier by Sergeant Paxton. That was a report that someone else had performed. I didn't request it. I didn't participate in it. I didn't know anything about it until he sent it to me. And they talked about steering it somewhere. I didn't steer it anywhere other than to the legal file for when the civil litigation
As I understood,
became ongoing.
People were just copied on the emails, how I understood the testimony. Maybe I misheard it. I know that they said steered it. I think they were trying to figure out why they were CC'd on some emails, but that's neither here nor there. But I accept your testimonies that you were just trying to get to legal.
Well, I just wanted to preserve what had been provided to us without any comment on it, other than yes, it does go to causation, but without providing it to anyone any further to further any narrative on the cause of death.
Right, but then look, I mean, you are the legal department, you're a participant of it. Really, all you got to do is hit the save button. I mean, it's not that difficult.
Yes, sir.
All right, quickly, Representative Marcel, because I really do want to move on. But
Attorney, it appears that you're looking at your phone. Is someone sending you notes right now?
No,
while you
ma'am.
testify?
No, ma'am.
Questions?
I didn't bring a pen with me, although I did bring a legal pad. So I put 4 issues on the front
Okay,
of
I
my
was just
phone.
watching you continue to look at your phone.
No,
I was just checking.
I had just put those 4 issues down, so I knew that I would remember to address them with you.
Okay,
thank you. I appreciate it. I want to give everybody an opportunity to clarify the record, so I appreciate you coming to clarify the record for us. Yes, absolutely.